Okay, so I had some great questions. We'll start off with some pretty easy ones. The first was what happens when property is partitioned. So if you may remember that a partition results when you have joint tenants or tenants in common that can't agree on what they're going to do with the property. And so they file a motion with the court to ask that the property be partitioned. What does that mean? Well, they have a couple of options. They can sell the property to somebody else and then split the proceeds. Or A can purchase B's interest. So if A and B own the property together, A can purchase B's interest, and then A will get the property. So that's how a partition works. Any questions on that? All right. Seeing none. I had a question, or I received a question about the hypotheticals. I think it's not this question, but the question after. Oh, does somebody have a question? Nope. Okay, I guess somebody was just coming in. Okay. So here is the hypothetical. S conveys Greenacre to A, B, and C as tenants in common. So we have A, we have B, and we have C, and they have their tenants in common. Shortly after, A sells his interest to F, then B dies, and he devises his interest to G, and then who owns the interest in Greenacre? Well, it's F, G, and C as tenants in common. So I think the question was about the second part of this hypo. So we're going to suppose instead that the grant read to A, B, and C as joint tenants with rights of survivorship. Okay. Would that change the results? And the answer is yes. Here's why. For a joint tenancy, you need to have the 4 unities. And one of those 4 unities is that you all got, or A, B, and C all got the interest to the property at the same time. If there is a transfer, that means that the transferee, the new person, got the interest at a different time. And that breaks the 4 unities. So it will sever the joint tenancy. But it'll only sever the joint tenancy for the new person. So let me explain. All right, so let's say A transfers the land to F. Now we have 2 different types of relation. Uh-oh, what did I do? There we go. 2 different types of relationships. We have B and C still have their joint tenancy. But now F is only a tenant in common. So the relationship that F has to the land is a tenancy in common. So if you're writing out the interest, it would say F as a tenant in common, B and C as joint tenants with rights of survivorship. So here's where that's important. B dies, and he wants in his will to devise the property, right, to somebody else. But in a joint tenancy, remember, you can't devise your interest because there is the right of survivorship. So as soon as B dies, C gets B's property interest. It doesn't go down to the person that B wants them. So then who's left with the property? Well, F and C as tenants in common, because they can't be joint tenants, right? Because they acquired the property. F acquired the property much later. Questions on that hypothetical? All right. Seeing as none, I'll assume that I explained it extremely clearly. We'll move on to the next question. The next question was to explain the difference between the American and the English theories on possession. All right. Well, before I do that, let's talk about what possession is. Possession, really, when we talk about possession and property, we're talking about two things. We're talking about the right to possess, and then we're talking about the actual physical possession. So you can imagine situations where somebody has the right to possess a property, but they don't have actual physical possession because somebody else is occupying the property, right? So when we're dealing with landlord-tenant duties, and we're looking specifically at the landlord's duty, the question arises, does the landlord have the duty to deliver? Because one of the landlord's duties, so the landlord has the duty to deliver possession. So the question arose, do they have the duty just to deliver the right to possess? Or do they also have the duty to deliver the actual physical premises? So when we talk about the duty to deliver and the right to possess, what does the right to possess mean? Well, to have the right to possess, that means you will have a lease of some sort, right? You will have been given a document that says that you have the right to possess, or a conveyance of some sort. The statute of frauds applies to land transactions. And so almost everything, not everything, but almost everything is going to be in writing. All right, so let's say, how could a landlord breach this right to possess? Well, they could breach it by giving multiple people leases to the same property. That would be considered failure to deliver the right to possess. Okay. So what about actual physical possession? So all states, and both the American and the English rule, say that the landlord has the duty to deliver the right to possess the property. Where the English and the American differ is whether or not they require actual possession. I'm trying to find a different color. Here we go. Actual possession. Okay. The English rule requires that the landlord deliver actual possession. If he has not, he has breached his duty to deliver the premises, to deliver possession. Okay. The American rule says the only duty the landlord has is to deliver the right to possess. That's it. So while the English rule requires both the right to possess and actual possession, the American rule only requires the right to possess. So what practical significance does it have? Well, if you have a holdover tenant, okay, and a tenant that has stayed beyond his lease term, in the American, with the application of the American law rule, the landlord doesn't have the duty to make sure that the premise is empty. And so the argument against the American rule is really the only thing you're requiring the landlord the right or to do is to deliver the right to sue, right? Because here to get this holdover tenant out, the new tenant would have to be the one who goes to court and tries to evict or sue to get this person out. The English rule would require that the landlord make sure that the premise is available and empty. All right, does that make sense? On your face. Are there any questions? All right, hearing none, let's move on. I want to talk a little bit about the burden shifting with the Fair Housing Act claims. And so this relates to the Nathamer v. Brenneman Property Services case. And so the test that's set out by this court is that first, the plaintiff needs to establish a prima facie case. Once they do that, then the burden shifts to the defendant to articulate a language, right? Legitimate and non-discriminatory reason. That the plaintiff's application was rejected. Okay. If the defendant's able to satisfy this burden, then the plaintiff has to show that the defendant's reasons are pretext or that the material facts are in dispute. If they do this, they can avoid summary judgment. If they can't, then summary judgment will be awarded and the case will be dismissed. Okay. Questions on this? All right. I want to talk about.
Sorry, I do have a question.
Yeah, sure. Go ahead.
Can you, we see this a lot, the pretext, referring to pretext, but I'm not sure anybody's actually explained exactly what that means. Can you just tell me exactly, sort of.
Oh, yeah, sure.
But can you just clarify it?
Yeah, thanks for asking the question. So pretext just means that it is a bunch of BS, right? Like that's the best way to define it, right? So that they're just there are, in a sense, they're just saying that, right? So like it is not. I can look up a technical definition for you, but you're basically just pointing at what the defendant says and says that is not true at all. That is not the real reason. right? They're just saying that. That's not their true motivation. Let me pull up the actual legal definition of it real quick, as opposed to my it's just not BS definition, which I think is accurate. Yeah, a reason given in justification for a course of action that is not the real reason. It's more eloquently stated. So it's a reason given in justification of a course of action that is not the real reason.
Wonderful. Thank you. I appreciate that.
Yeah, no problem. Any other questions? Okie dokie. All right, seeing none, I want to talk about one more thing in regard to the Fair Housing Act. Let me add a couple more slides here so that I have some places to write. All right, so I had some pretty good questions about a particular hypo that talked about advertising that you want a roommate with a preferred native language of French, right? But let's say that instead of French, let's change the hypo to preferred native language of English, and that was in the hypothetical instead. So, the argument for the French hypothetical was that, well, maybe I just want somebody who I can practice French with. Or, why does this amount to discrimination? Why is this type of advertisement prohibited under the FHA? And the book just mentioned it briefly, but I want to touch on this idea of disparate impact. Disparate. I feel like I didn't spell that right. Disparate impact is actually, no, that's spelled correctly. So it's called disparate impact discrimination. And when I was in law school, we went over this in common law. I don't know that you all do. So I'm going to go ahead and chat about it real quick. You will hear about this if you take an employment law course. You'll hear about this in employment law because that's where it comes up often, but it also applies to housing discrimination. Disparate impact is when a rule is adopted that on its face does not seem discriminatory, but it adversely affects one group of people more than another. So it looks like it's a neutral law, okay? But in actuality, if you look at, and oftentimes they'll use statistics to prove disparate impact. If you look at the application of the law, it disparately impacts protected populations. And the reason that this is and the sharing has ended. Give me just a second. Apologies for that. Telemarketer called my phone. It went on my iPad and okay. Back to disparate impact discrimination. All right. So the reason this doctrine arose was because after facially discriminatory rules or practices were prohibited by law, employers and landlords started to become very sneaky, and they would come up with laws or practices that looked completely neutral, but they were used for a discriminatory purpose. Well, unfortunately, the defendants were having a very difficult time proving that the employer or the landlord had enacted that policy for the purposes of discrimination. And So in a line of cases, the Supreme Court had some cases on this as well. They basically decided that putting that burden on the plaintiff to show that the defendant enacted a facially neutral law to discriminate was just too much. There's no way that we're not going to prevent discrimination if we allow that. And so as a proxy, they said that if a practice has a disparate impact on a protected group, and that can be shown, then that would be considered discrimination. So in our example, if you talk about a preferred native language of English, that is going to have a disparate impact on, like let's say you're in Southern California, all right? Let's say you're in San Diego, which is right on the border with Mexico. Laws were like that would be used by landlords to try to get out of allowing for immigrants to rent. Okay, so I just wanted to explain so we understood the purpose of it, because it seems innocuous, or it seems like it's not harmful on its face, right? What's wrong with saying you want somebody who speaks French? But in essence, what you're doing is you're discriminating against people of other national origins. Questions? All right. I had another good question about civil unions and what property rights do folks have if they have a civil union? Okay, well, first of all, civil unions are only recognized in 5 states currently: in Colorado, Hawaii, Illinois, Vermont, and New Jersey. And in those states, a civil union is equal to a marriage as far as property rights go. So civil unions, kind of the history of it, civil unions were used as a way of advocacy groups to say, hey, we understand that same-sex couples want the same legal rights as non-same-sex couples, and so we just object to it being called a marriage because a marriage has religious connotations. So instead, let's call it a civil union. It'll be exactly the same thing, but have a different name, and then we'll be okay with it. And so so legally in these states, the civil union has the same rights as far as property goes. I want to talk about another couple of arrangements that the book did not touch on, but one of them was on one of the bar exams that I took, so I feel like we should talk about it. It was not a state that did the uniform bar, but still, I think it's worth mentioning. Okay, so let's talk about domestic partnerships. And you might cover this in your family law classes. I'm not sure, but all right. So domestic partnerships are recognized in California, DC, Maine, Nevada, Oregon, Washington, Wisconsin, and Hawaii has something similar, but they call it reciprocal beneficiaries. Okay. So what is a domestic partnership? A domestic partnership is an arrangement where 2 individuals live together and hold themselves out as a long-term couple. Okay, but they have not gone through with a legal marriage. Okay, so if the state recognizes a domestic partnership, then the state typically, I mean, okay, granted, I only know California and Nevada law, but in California and Nevada, I suspect the other states as well, if because the state recognizes the domestic partnership, then they have the same rights to property as a married couple. By the way, domestic partnerships usually have a certain number of years that you have to be together for it to be a, anyway. So in California, for example, California is a community property state. So in California, the domestic partners have the same community property rights as a married couple. The last type of legally recognized relationship, and this was the one that was on my bar exam. Even though I took the bar exam in a state that does not recognize this type of relationship. It's called a common law marriage. So common law marriages are recognized by Colorado, DC, Iowa, Kansas, Montana, Rhode Island, South Carolina, Texas, and Utah. In a common law marriage, you have to have both couples hold themselves out as being married. But they never actually went through the legal process, or there was some type of technicality or difficulty with the legal process. Where have I seen, so with a common law marriage, they have the same rights as a married couple as far as property is concerned. Same, it's as if they're married. So the property question that I had on the Nevada bar exam many years ago was, and Nevada has a notoriously hard bar exam. I mean, I think it's harder than California's. I've taken both. I think it's harder. I'm not saying you were going to get this question, but again, I feel obligated to tell you because it was on my bar exam. The question had the couple moving from a state that recognized a common law marriage, which was Texas, to Nevada, which does not recognize common law marriage. So what happens then, right? And the answer to the question, which, by the way, I got the law wrong and I still passed the bar exam, so that goes to show you it's more about the application and the issue spotting than it actually is by getting the law right sometimes, because I thought Nevada recognized common law marriages, and Texas didn't. I had them switched, but anyway. So the hypo was that this couple moved from Texas to Nevada, and they had acquired, all this property, like $100,000 in Texas, and then they moved to Nevada, and then they bought a house in Nevada. And the question is, well, how do you split up the assets when they separate, when they end the common law marriage? And the answer is that because in property, you always apply the law. I don't know when we're going to go over this, but you always apply the law of where the property is located for real property. And so you can kind of extend that rule and say, I'm going to do the same thing for assets. So you look here and you say, all right, well, this is marital property. And then I apply whatever if Texas is a community. I don't remember if Texas is a community property state or a separate property state. Let me Google so I don't give you wrong information. And yes, I got my JD from the University of Texas. Community property state. Yeah, Texas is a community property state. Okay, so that would mean each person would get $50,000. Those assets would be split up that way. Then in Nevada, Nevada doesn't recognize a common law marriage, so they're just separate people. So when they bought the house, it depends on whose assets were used to pay for it. It's treated like separate property. Okay. So again, not saying you're going to get a bar exam question like this, but these are the types of questions that if you take the bar exam in a trickier state, you may get questions like this that ask you, all right, so how do you divide up property? How do you divide up property when you have a domestic partnership or a common law marriage and the state doesn't recognize that it's the state they moved to doesn't recognize it's a common law marriage? All right, that was probably too much information, more than you wanted, but again, this is not going to be on your quizzes or your exams. This is just FYI in case when you're doing bar prep, you have some. Okay, questions on this? All right, last thing I want to talk about is conditions of the premises. And this, again, it's not going to be on the exam, but I wanted to talk about this interesting intersection between property law and health law, because I'm a health law scholar, and I can. Okay, so a lot of those cases that we looked at, all right, or the cases, that had mice or that had sewer problems, you'll notice that they emphasize violations of health codes, right? Landlord-tenant problems are a big issue in healthcare delivery. And so much so that housing and it's considered part of environmental health, and it's considered a social determinant of health. So a common scenario, not too uncommon scenario, you'll have is, for example, when I was in Ohio, there's a hospital called Nationwide Children's Hospital. It's a big children's hospital. And they would have children presenting to the emergency room with lead poisoning. And so the doctor can treat the lead poisoning, but then they send the child and the family back to that home that has the lead. The doctor, the healthcare system, can't do anything about this hazard. Sure, sometimes the doctor would refer or try to tell them, go seek an attorney. Well, people don't have money to go get an attorney to fight their landlord, or they might be scared that there would be retaliatory eviction, right? And so the child would keep presenting with issues, or there are cases where the child died. And as a result, these partnerships develop. They're called medical legal partnerships. And what they are attorneys, right? And a lot of them are started as clinics and law schools. They will actually have an attorney at the hospital, right? So in essence, the doctor writes a prescription for legal services. And oftentimes those legal services are landlord-tenant issues. They also could write a prescription, for example, for people who are have problems with Medicaid or Medicare denying things that they shouldn't deny. But the bulk of what these medical legal partnerships get are cases that involved landlord-tenant problems. All right, so I just wanted to impress how much of an effect, you might think that like landlord-tenant law, sounds pretty. You represent the landlord, you're kicking people out, or you represent the tenant who usually doesn't have money, or, the only time you're going to get paid is if you do a big commercial. Well, what I'm trying to say is there's a lot of public interest work that is actually centered around healthcare that has to do with landlord-tenant law. And so I'm happy to share those examples and opportunities if any of you are interested in doing work with medical legal partnerships. They're very, very interesting work. There's also a national organization, and I don't remember the name of it now. There's a TED Talk on this, though. And what they did was they created groups of undergraduates who would go sit in the hospital emergency rooms, and doctors could write prescriptions to whatever the patient actually needed to get better. So, for example, if the child is malnourished, there's not much the doctor can do because the child needs food, but the family doesn't have food, right? And what does the doctor do? Well, because we have what's called a hidden or a hidden welfare state, we don't actually, it's the doctor, everybody presents to the healthcare system when even if they have a legal problem or they have inability, so what do they do with these patients? Doctors get really frustrated, and we're billing hospitals and it costs a lot of money. So these groups of undergrads would sit in the hospital emergency room or have an office there. The doctor would write a prescription for whatever that family needed. So if that kid needed food, if that kid needed vegetables, if that kid needed vitamins, they would write it on a prescription, and then they would send it to this organizational representative. And what they did is they're what I call care coordinators. Hospitals are now hiring care coordinators as well. It's another conversation, but they help the patient navigate our complex system in order to get the things that they need. So they would they would follow up with that person right there in the hospital, get them signed up to make sure they can get, food benefits, for example. Make sure that they navigate the complex regulations, eligibility requirements, and so forth. And they connect them with groups in the community that can help. And they follow up and they make sure that. So there are all these opportunities, and I'm just saying this to impress on you all that there are all these opportunities in the healthcare system to do good work, and a lot of it ties in with property law. So although it seems odd that I'm a health law scholar teaching property law, there's actually a lot of overlap. Anyway, that's all I have for now. Does anybody have any, and again, that won't be on the exam in case anybody is wondering. Oh, about your quizzes. I am grading them. I am planning on trying my best to finish them today. I'm writing a lot of comments because my thinking is that, the purpose of this is for you all to see what I'm looking for. You'll get a rubric, you'll get comments. We just had, of course, some technical difficulties in the downloading of your exams. So they're all in one PDF. So now I'm going to need to work with one of our staff to try to split everything up. So I'm just saying this to let you know that there's a little bit, I'm trying as fast as I can to get them to you, but it is, there's some technical difficulties. For example, we could only download your answers by question. So I have like an Excel spreadsheet with the first 26 questions for each of you. So we got to figure out how we're going to split that all up and get you your exams back. It's a bit of a mess, of course, but again, that first quiz, it really is to help you see. So I'll make sure you get it well in advance before the next quiz. And remember, you have the option to decide to exclude the grade, and you can wait till after you get your second quiz grade to do that. Okay, any questions? Hearing none, we're going to end. All right, you all have a wonderful weekend. Enjoy.